I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that...
All right, everyone. Today we're looking at one of the most frustratingly annoying sovereign citizen cases I've ever seen in court. Judge Hillman took a different approach this time. He chose patience instead of shutting the guy down right away. This makes the whole situation pretty interesting. But here's my question. When should judges stop entertaining this nonsense and just hold these people in contempt? Personally, I think the judge could have handled this way better, but I won't spoil anything. So, let's dive in and watch this sovereign citizen get completely taken down.
You say I'm driving a vehicle? Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving while you're...
Give me 15 seconds, I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
firsthand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I disagree. It's tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir, that's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtain, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is...
On what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my ground.
This is exactly the problem I have with most judges when dealing with sovereign citizens. They need to be way firmer. I mean, this judge seems like a good guy, but he's just way too patient with all this nonsense. It's clear this sovereign citizen is taking advantage of that patience, trying to drag things out because the judge isn't shutting it down quickly enough. Come on, man. At the very least, the judge should threaten contempt by now. It's so frustrating watching these people get away with it. I don't know about you, but it's really obvious this guy is just playing games with the court. Let me know what you think. Now, let's dive back in. Hopefully, the judge puts an end to it this time.
And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He's coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
first-hand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that...
All right, everyone. Today we're diving into one of the most frustrating sovereign citizen cases I've seen in court. Judge Hillman took a different route this time. He opted for patience instead of shutting the guy down immediately. That definitely makes things more interesting. But I've got to ask, at what point should judges stop humoring this nonsense and just hold these people in contempt? Honestly, I think the judge could have handled it a lot better, but I won't give away any spoilers. So, let's jump in and watch this sovereign citizen get absolutely dismantled. Citizen cases, I just can't think of a single case where this would be a good idea, but then again I've never read over their script, so I can't say for sure, but let's dive back in.
I got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Okay.
He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst. Okay,
Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again, okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed. Yes.
So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from? My notary sent it. The Notary Republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, he's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
Does anyone else think it's about time this guy gets a lawyer? Seriously, I'm cringing for the judge right now. At what point do we just call it? For the love of all things legal, give this man a contempt charge for wasting everyone's time. He's said objection over 30 times already, and not a single one has made any sense. It's like he thinks if he says it enough, the court will just give up and let him win. Contempt exists for a reason. It's meant for people like this who refuse to follow courtroom procedures and just stall the whole process. Honestly, at this point, he either needs a contempt charge or a competency hearing because something is definitely not clicking here. What do you guys think? Would you have thrown him in contempt by now, or just let him keep cooking up this nonsense? Also, if anyone knows how many times he's said objection so far, let me know.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes,
under penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all gap procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want him to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking and answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources.
The plaintiff is seriously wasting the court's time right now. I honestly can't tell if this guy is just one of the dumbest people alive or if he's trolling the entire courtroom for fun. Like, sir, you're literally the one dragging this out. The judge, the attorneys, the court staff, everyone is stuck here because you refuse to follow the rules. And we all know why. He's just trying to stall, hoping that somehow delaying the inevitable will make his problems disappear. The court isn't going to forget about your case just because you've wasted time or shouted objection over 100 times. That's the thing with these sovereign citizens. They scream about their rights but conveniently forget their responsibilities. It's honestly kind of funny. The law is clear. If you file nonsense, refuse to follow procedure, and waste the court's time, that's on you. But of course, accountability isn't in their vocabulary, just like a lot of other important words. What do you guys think? Is this dude just clueless? Or is this all one big game to him?
Coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no? Can you just for the record? So there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor. Have a nice day.
This guy is definitely mentally ill. No joke. There's just no way he actually thinks this stuff is going to work. The funniest part? He looked the judge dead in the eye and smugly said he'd just appeal and get it overturned like it's some kind of guaranteed cheat code. Bro, that's not how appeals work. Appeals courts don't just hit rewind because you didn't like the outcome. They only look at legal errors, not "I didn't get my way" complaints. So unless the judge straight up violated your rights or ignored the law, you're just throwing more time and money down the drain. Honestly, reality is about to hit this guy hard. And the judge should have done it too. I think the judge should have been way harsher here. I'm usually pretty tough on judges, so tell me if I'm wrong, but I feel like the judge should have laid down the hammer a bit more. Still, this whole thing was a masterclass in what not to do in court. If you ever find yourself in a legal battle, don't take notes from a sovereign citizen. Even though I was critical of the judge, his amount of patience was wild. At the end of the day, the law isn't going to bend just because someone refuses to accept it. Sovereign citizens can argue all they want, but the legal system doesn't care about their made-up rules. It's like arguing with gravity. No matter how many times you say it's fake, you're still going to hit the ground. Anyway, I'm wrapping this up here. Let me know in the comments what you think. Was this dude just trolling the court, or did he actually believe he had a chance? And if you enjoyed this video, don't forget to like and subscribe for more content. I post every single day, so stay tuned. Thanks for watching, take care,